Hi, everybody. My name is Arnie Schneider. I'm a member of Beth Jacob. I've been a member for about 39 years. I've also been a member of the Beth Jacob Board of Trustees for about half of that time, about 20 years. And during 3 of those years, I actually served as president of Beth Jacob. Nowadays, for the past 10 years, actually, I've been a member of the Beth Jacob Legacy Fund Board. So now let me introduce our guest speaker, Rabbi J. Lyons, who is the Southeast Regional Director for the National Association of Chevra Kadisha and founding director of South Florida Jewish Cemetery. In this capacity, he provides eye-opening and inspiring educational workshops on the Jewish view of body and soul, end-of-life issues, and perspectives on quality of life. A native of St. Louis and Chicago, Rabbi Lyons began his involvement in Jewish education when he was a teenager, taking active roles mentoring other teens. Known for his wit, enthusiasm, charisma, and warmth, Rabbi Lyons is an innovator who is strongly committed to advancing Jewish knowledge and connection across the lifespan. In addition, his dedication to the Jewish people is evident in the many communal responsibilities he has assumed in Boca Raton, Florida, where he and his wife, Jordana, live with their children. So now I introduce to you Rabbi J. Lyons.
Hi, everybody. I am Rabbi Yaakov Lyons with the National Association of Chevra Kadisha. This program is sponsored by the Beth Jacob Legacy Fund, and this is part of the Legacy Month, which is a wonderful program. I wish every shul in America would have it. A special thank you to Mrs. Zahava Kurlin for all of her help. And what we're going to talk about tonight is really 2 different issues that are separate from each other, but they do have a little bit in common from the preparedness point of view. The 2 issues are what's oftentimes called a halachic living will, otherwise known as Advanced Medical Directives, otherwise known in Georgia as durable power of attorney. And we'll talk about that. And then the other issue is the last will and testament, and dealing with that from a halachic point of view. The overarching principle with all of this is the reason why it's important to take these issues seriously and to be prepared is because the last thing that any of us want is for those who are left behind, or when it comes to advanced medical directives and not left behind, we're still here, but they're the ones making the decisions. We don't want anybody to be questioning what we would want. We don't want anybody agonizing over what we would want, and we certainly don't want anybody fighting over what we would have wanted. And therefore, it's very important that there's clarity. Very, very important. There's clarity in what we want. And to be passive and to just let the law take over, that does not create clarity. To take a moment right now, and we're going to go through the Advanced Medical Directives forms. We're going to go through literally as we speak, filling it out. It's not that complicated. You'll see that it's the type of thing that you probably could figure out and do it. The last will and testament, the halachic will, if you will, or more appropriately, the halachic will addendum, is the type of thing that you do need a professional. We would strongly recommend that you have a professional lawyer go through your will with you to make sure that it is legal and would be upheld in Georgia court. But then the halachic will addendum is readily available online. There are a couple of different versions. They all sort of do the same thing, but it's really irrelevant until you have the will. And so that one we're not necessarily going to go through step by step, but we are going to go through an understanding of why it's important to have the halachic will addendum. Okay, so with that, we are going to get started, and I'm going to share my screen here with you. Okay, so this is a step-by-step Advanced Medical Directives, and again, we're here to make this easy. This is sort of one of these forms. It's like, ooh, it's one of those forms. But the reality is we're gonna sort of take the edge off, and you'll see how that goes. So this is part of Team Shabbos. Team Shabbos is a great program that NASCK, National Association of Chevra Kadisha, puts on, usually around Parshas Vayechi. So we're a little bit off from there, maybe exactly a half a year. And that's fine. That's no problem. Anytime is a good time to be aware, be responsible, and be prepared. So congratulations to all of you for doing that. Okay, living will. That's what we're talking about today. So what does a halachic living will do? So the answer is that it empowers people who love you to make decisions based on specific circumstances. And what that means is as follows. Hopefully you saw the video that went out with Rabbi Pesach Krohn. The question to ask yourselves is very simply, if God forbid, I was in a situation where I needed medical attention and I was incapable of communicating, who would I want to be making decisions for me? Now, most people have an answer to that question. Most people know who that person would be. Now, I have a follow-up question. My follow-up question is, if that person was not available, for whatever reason, unavailable, incapable, who would I want as the alternate? Most people have an answer for that question. If you can answer those two questions, you can do a halachic living will tonight. You can fill it out tonight. The next question is going to be, what rabbi would I want them to be consulting with from a halachic point of view? And most people have an answer to that question as well. So that's the idea. What we're doing here is that we're going to make a document which is going to empower those people, which we'll get to. Okay. It instructs everybody to follow halacha, and everybody means the person making the decisions, you know, your loved one. It also means the doctors. We want everybody to do the right thing according to halacha, because that is your wish. That's the way you live your life, and that's the way that you want people to be making decisions on your behalf. Okay, it creates a proxy, surrogate, agent. All these words are interchangeable. Power of attorney. All these words are interchangeable. It is a representative who makes decisions on your behalf. That's the idea. And then it also involves a Rav of your choosing to guide the power of attorney and the medical staff. Okay. Patient autonomy. So this was also mentioned in the video. Patient autonomy basically means that the patient decides what course of action is right for them. So for example, let's say you were a patient was consulting with their doctor, and their doctor told them, we have two different choices here of what we can do, and this one is a little bit risky. And the patient said, I want to take the risk. So from a moral point of view, is that right or wrong to take that risk? Obviously with some, with some exceptions with the drastic risk or something like that. But that's right for the patient, because the patient said it was right, so therefore the patient's right. Right? The patient gets to decide. The patient says, that they want this, this procedure. They don't want the procedure. This is against my will. This is what I want. This is against my religion. This is what I want. Whatever it might be, the patient is right. So the issue becomes, what if the patient can't communicate? That's what we sort of referred to earlier. And the answer is that Advanced Medical Directives name an agent, surrogate, power of attorney, and a rabbi. I make it clear that they want everybody to follow Jewish law. And so the idea is that the agent, the power of attorney, is speaking in the place of the patient. So the same way that the patient can say, this is right for me, this is what I want, and that's what the power of attorney is doing also. And here's how we said it before also, that if, God forbid, you need a medical care and we're incapable of communicating, who would you want to be making decisions on your behalf? If that person was unavailable, who would you want making decisions? And which Rav would you want them to consult with? There's another one, of course. If that Rav is unavailable, who would be your second choice for the Rav? Okay. If you can answer all of these questions, you can fill out the form. You can do it right now. So if you do not have the form in front of you, which I believe it went out in an email. So either you can search the email from the Shul and print it out from there. That, I guess, would be the shortcut. Or you can go to NASCK.org. That's NASCK, like it says in the corner there, .org. And then if you see the tab on the menu for the MS card, which I'm going to point to with my cursor right there, then you're going to click on that. And then that's going to get you to a form that says download whichever one you want. So we're going to go to the download the Agudas Yisrael for your estate. If you want to do the Rabbinic Council of America, that's totally fine. Very slightly different, almost verbatim the same, except for the use of the word agent. And maybe one or two other minor changes. Okay, so now with the form in front of you, we are going to fill out the form together. I'm actually going to leave this screen and go to the Georgia form. Okay, so the Georgia form is durable power of attorney. This is already page 3 of the form. The instructions you can disregard for now. So page 3 of the form. That would be your name right there, your legal name as it appears on your driver's license. If you need to look that up, you can. Just kidding. There you go. Hereby declare as follows, that you appoint an agent, and the idea is that you might not be able to make decisions on your own for medical care, so you're going to put the name of the agent. That is the name, address, and daytime and evening phone number of the person who you would want making decisions on your behalf if, God forbid, you were incapable of doing so. What if that person is unavailable? So then you would have the successor agent, is what they call it over here, right? That is the alternative. So your successor agent would be the next person. If your first choice is unavailable, then this is going to be your second choice. So far, very easy. You might need to look up names and addresses. I would recommend you put the name there right now and then maybe look up the address later, unless you can do it while this is going on, and that's fine. But we definitely do want to fill this out as we go if you're able to. Okay, number 2, Jewish law should govern decisions. So this is a very basic statement of just I am Jewish, it is my desire, and I hereby direct the Jewish law according to Orthodox interpretation as follows. And then, without limiting if we're going to have a couple of different examples. So, for example, you want CPR, you want life-sustaining surgery or procedures to be initiated, etc. Now, the last line is very, very, very important, which is the last few lines. So one is that nutrition and hydration are different than medicine. They are not the same thing, and therefore they should not be withheld. That's number 1. And then the last line is the criteria by which death shall be determined, including the method by which such criteria shall be medically ascertained or confirmed. All of that is to follow halacha. Crucially important, because depending on where anything happens, state law could have a certain definition of death, and that definition of death might not follow the halachic definition of death. So I have seen more than once where the medical staff declared the patient dead, and then after the demise of the patient, the healthcare agent is no longer having any authority because there's no longer healthcare for somebody who's dead. And therefore, they did not need to listen to the healthcare agent, and therefore they remove the person from the machines, etc. So we want the criteria by which that should be determined. That should be determined by halacha, and the method by which such criteria is medically ascertained should also follow halacha, because there are certain tests that the tests themselves are, from a halachic point of view, too risky. And a person should be able to say, no, I'm not having that test. Okay, now, what we just did is that we just said, this is my agent who I want to be able to speak in my place. I want everybody to follow halacha. Who determines halacha? Who determines what the halacha is? What's the answer? The answer is, you do. You, the patient, determine what the halacha is, because we just said before that there's patient autonomy. And if a patient says, this is against my religion, I don't want it, so then the doctor shouldn't do it because the patient's saying they don't want it. But of course, we're talking about a situation where the patient is incapable of speaking. So now the patient needs to take charge, which is what we're doing right now, and we're saying that Jewish law should be ascertained by consulting with the following rabbi. This is my rabbi, this is who I want everybody to consult with and to collaborate with. And so that's going to be your rabbi. And then we have another thing, if such rabbi is unwilling, unavailable, etc. So then you have your alternate rabbi, your successor rabbi. This is an option here. If you don't want it, you can cross it out. But if both rabbis are incapable, unavailable, whatever it might be, so then you can name an organization. And the idea behind this is that there are organizations that have a hotline that you can call. I don't have the information in front of me and in no specific order, but the two that pop out, I know there are more. Yeshiva University has some type of hotline, and Agudas Yisrael under the name Chaim Aruchim, which is a division of the Agudah that deals with these issues. They also have some type of hotline. So you could do that. You can name an organization. You can name a yeshiva. You can name whatever you want. You can cross that whole organization part out should you wish to. And the idea here is, of course, that everybody can assume that the rabbi is acting in good faith and doing my wishes and following Jewish law, and okay, and that's how we do it. Okay. Now, this is specifically, number 4, section 4 here, is just specifically directing the medical staff to follow the agent and the rabbi. That's really all number 4 is doing, but it's just that's the specific directive to the medical staff. And then also the last line of it is, pending such contact, that you want all essential life-sustaining procedures, measures to be done. So number 5 is HIPAA. HIPAA is a great law. HIPAA is, I know some people don't like the way that it's written, but the concept behind it is a beautiful thing. It's patient privacy. Really a doctor can't even acknowledge that an individual is their patient, without the permission of the patient. So that creates a little bit of a problem here potentially, because how can the doctor openly discuss an issue with the healthcare agent or the rabbi if they need to follow the HIPAA laws that keep all of that information private? So what this does is it says the patient, I'm saying that I want the doctor and the agent and the rabbi to all collaborate as one cohesive team. And I need them to share whatever information they need to share, and don't worry about patient privacy, because everybody is on my team, everybody's working on my behalf, and that's exactly how I want it. I want the rabbi, the doctor, and the agent to all be working together. Okay, now that's really the end of, not really the end, but we're going to move on to a little bit of a tangent to number 6. But up until now, again, just to review, we said that there's patient autonomy. The patient makes the decisions. What if the patient can't communicate? So then the patient is able to make an agent. That healthcare agent can make all the decisions and speak really in the place of the patient. We're going to instruct everybody to follow halacha. We're going to instruct everybody to consult with a certain rabbi and an alternate rabbi if the first rabbi is unreachable. And now everybody's going to assume that everybody's going to follow the rabbi from the halachic point of view. The medical staff has been instructed to follow the instructions of the agent and the rabbi. And we've acknowledged that there is something called patient privacy through HIPAA laws, and we're saying that we do want whatever information is relevant to be disclosed to the rabbi and the agent so that everybody can make a decision together. Post-mortem decisions, number 6. Now there are a few things about this document, the Halachic Advanced Medical Directives. So you can go to any hospital in America and you can get a form. There'll be a 1-page form that you can create a healthcare agent, but those forms come with a few different problems. And obviously, one big advantage of the halachic living will is that it gives you a spot to mention the rabbi, obviously, and the fact that it says that you want emergency treatment and that you want halacha followed. So all of those are obviously major advantages to this form. But this one is another one because post-mortem decisions do not exist in a normal, conventional, I should say, living will. And as we mentioned before, the healthcare agent, their authority really ends at the death of the patient because there's no longer health care. Now, we, from a halachic point of view, of course, care about the body as well, even after the neshama has parted. And so we want to be able to have the same authority of the patient themselves, individual themselves, able to direct the medical staff. And so, number 6 is that it is my desire that the authority basically continue after my death. When halacha followed according to Jewish interpretation, as far as dealing with the body, so for example, expeditious burial. And then this is also an objection to autopsy. There's an objection to autopsy, and it's an objection to organ donation. Now you're going to say, wait a minute. What if I want to participate in organ donation? So it goes like this. Organ donation is a complex halachic issue. And the idea behind this document is to make it in such a way that it's simple enough that everybody can use it. We're going to talk about the MS card afterwards, which is going to be the pocket card, the Cliff Notes version of this, and it's going to have the same language. And the idea behind both of them is that, and this is the RCA, the Aguda, everybody has the form like this, and it basically uses this language. And the idea is that I'm going to oppose organ donation, I'm going to oppose an anatomical gift, unless I stated otherwise in a different document. And what that does is that has a certain clarity over here, and is neat and clean. And then with whatever specifications of your Rav apply to organ donation from a halachic point of view, so then you can have that document and you can flesh that out a little bit better. Your healthcare agent and your rabbi should both know how you feel about this issue, and you should consult with your rabbi about this issue because it is a major halachic issue, and it is a life or death halachic issue, both for both the donor and the recipient. So it is a very heavyweight halachic issue, and should be taken very seriously. Should be spoken to about with your rabbi, and whatever you do, that decision should be known to the should be made known to the agents and to the rabbi. Okay, number 7, incontrovertible evidence of my wishes. This is basically almost like legal stuff, basically just saying that if somehow, some way there's something wrong with this document from a statutory point of view, but it's very clear what I want. And in fact, I'm not a lawyer. I meant to say that from the beginning. I'm not a lawyer. I'm not giving any legal advice here. I have not yet. There's an ICU doctor, retired ICU doctor in my community that I've discussed this issue with him a lot, the entire document. He had some interesting insights, but one of them was that, obviously if you're in Georgia, you're going to be doing this based on Georgia law, but then what happens when somebody travels, to Colorado or something like that? So he's saying there's no doctor in America that would say something to the effect of, well, this is a Georgia document and we're in Colorado or something like that, because it's very clearly the wishes of the patient. And it's not like every time a person travels across state lines, they need to have a new Advanced Medical Directives that would be just, very, very onerous, and nobody would be expected to do that. Okay, now don't sign this. Don't sign this, people. Don't sign this yet. But duration and revocation, so this is an important thing because basically it goes like this, that this is in effect forever, unless you do a new one and then the new one would basically take the place of the old one. Why is that important? So one is that if you've done this already but something changed and you're doing this today, so then the one today is going to take effect. The other thing is, sort of the opposite way of looking at it. If something changes, so like for example, whoever a person named as their rabbi or their agent, for whatever reason, that person is no longer capable. So, why go through the exercise of trying to find that person? Probably better to write a new one and name a new agent and a new agent successor, or a new rabbi and a new alternate rabbi, if the person on the document is not there. Now, signing this is very important. You want to do this in front of witnesses. And and that's what's going on over here. If you are signing this at a hospital or a skilled nursing facility, then you do need to do that last page also, depending on where you're doing this from. But you definitely want witness number one, witness number two. A couple things to keep in mind here. Very, very important. First, we'll talk about the witnesses. So really anybody can be a witness. They don't need to be a halachic witness. However, they cannot be, let me go back to my, my PowerPoint here. However, they cannot be related to each other. The witnesses cannot be related to you, who's signing the document. The witnesses cannot be a party to your will or to your estate. The agent can. That's fine. It's no problem that the agent is a party to your estate, but the witnesses cannot be. And hold on, sorry. And it also can't be if you're in the middle of a lawsuit with somebody who, if they would win, they would collect from your estate. Then that also can't be a witness in case that's the case. The office at Beth Jacob, I believe, is going to try to make themselves available, certainly by appointment, that they can have two people who could be witnesses for you. You really can just knock on a neighbor's door. Of course, the issue is you knock on a neighbor's door and you have the husband and wife there, so those two people are related to each other, so they can't serve as both witnesses. But if you can somehow figure out how to do this, it's really, really super duper important. I would also say like this, that there are plenty of times where we do these programs and people are very inspired to do this, and they realize how easy it is. If you don't take it to the finish line and complete it and get it witnessed, then you forget about it, and then it doesn't become, and then years later you remember that you didn't do it. So really, put it in your calendar, call the office, do something, somehow get together, let three couples, all get together at somebody's home, and two people who are not related to each other can witness for the others, and really do it like that. Let's say you do this and you do everything right and you get it witnessed and you scan it and you email it to the agent and you email it to the alternate agent and you email it to the rabbi and the assistant rabbi and whatnot. It's also important to email it to, you might have close family members who are not the agents. It's important for them to know about it. It's important for them to know, who is and who isn't the agent. And again, as far as God forbid, children fighting over what does mom want, it's maybe uncomfortable at first to say this child is the agent, this child isn't, but it creates a clarity and it creates shalom, it creates peace at the time. I would tell you personally, I am one of two children. My sister is my parent's agent, and I'm not, and there are reasons for that. Some of them are geographic, but it is what it is, and I know my place. So that's the bottom line, and that there is an amount of peace that comes from that, because I will defer to my sister because she is the agent. I'll tell you another story within my own family, that an uncle of mine has 4 children, and one of them is a nurse. And even though she's not the oldest, she's not the closest, but she is a nurse. And so he wanted her to be his agent. That's his decision. Doesn't mean that you and your own family, if you have medical professionals, that they have to be your agent. It's not like that, but that was his decision. There was a point where he was not doing well at all, and we were very, very frightened about the future. And she was able to really take charge and able to speak the language of the doctors, and had a very good result. And Baruch Hashem, he's doing great. And but again, what were the other siblings doing? They were deferring to her because she was the agent. Okay, let's say you do all that. What would happen if, God forbid, a person is in a situation where you have 911 call, they have an EMT, they're not under the care, not under the immediate care of their family physician who knows who their agent is. By the way, your own doctors should of course know that you filled this out, and you should discuss this with them as well. But let's say that doesn't happen, right? Let's say it's a situation of an EMT. So we make it easy. How are they going to know? How are they going to know you did this? So the answer is there's something called an MS card. And the MS card is like this. I'll pull out my own MS card. In my wallet, it attaches to your driver's license, right? So here's my wallet, here's my driver's license. going to try to do this in focus here. If you can see, there's a plastic thing that says see medical instructions on the back. If you go to the back of the card, then you have a card like what you see over there. And the MS card is the Cliff Notes version of the Advanced Medical Directives. And first responders are going to look for your driver's license. They're going to see that. They're going to know that you have a healthcare agent. They're going to call that healthcare agent, and they're going to follow instructions from there. But the point is that the MS card is so brilliant because what you have is attached to your driver's license, you have the contact information of the agent. And that's super important if, God forbid, somebody would need medical care, in the middle of nowhere, or even at the middle of nowhere. Okay, the other thing is, once we're being so responsible, if you put ice in your contact, so, even if you're whoever that would be, your husband, your wife, whoever the emergency contact is, ice is in case of emergency, and the first responders, if they can get into your phone, will look for that. For more information, you have your RUV, which is a wonderful resource, and you have NASCK.org, which we were at before, and if you need to reach out to me for any reason, you certainly can. I can try to be helpful. Rabbi Lyons at NASCK.org, and I'll leave that up there for a moment while we transition. So, and again, I can't emphasize enough two things. First of all, is congratulations to you for being here tonight and for doing this, and really take it to the finish line. This form is very simple. Anybody who knows who they would want to make those decisions can fill out this form. Please fill it out. Please witness it. Sign it in front of witnesses, and send it along to to your agent, alternate agent, your doctor, your rabbi, and all of your loved ones. If you do that, so then on NASCK.org there is a way to you can contact us, and we will send you an MS card in the folder in the sleeve for free. So please do that. Okay, want to transition to the next part of our program. And what we're going to talk about here is the halachic issue behind it, and how inheritance works from a halachic point of view. We are going to talk about the need for a last will and testament in light of the halachic inheritance, and we are going to talk about how to make all of that work together. Okay, so those are going to be our basic. I'll say those three categories. So basically, very simply, this was from it was mentioned in this past week's parsha with Ibn Slavchad, but it was also a few weeks ago where it was originally brought up with the Ibn Slavchad. So the order of inheritance, the way that the order of inheritance works is a fairly simple system. It's a fairly simple system. It seems to be more complicated than it is, but it basically goes like this. That let's say for a woman. So for a woman who's married, her husband is the sole inheritor of her estate. For a woman who's not married, or for a man, whether or not he's married, so then it goes like this: that there's the son, right? The sons inherit and have priority to the daughters. There is a bechor. The idea of a bechor is it is the firstborn son, and he gets two portions. So let's say a person has three sons, or which keep it very, very simple. Let's say he has three sons. So one of them is a bechor, obviously. So we will say, okay, well, so the bechor gets two portions. So we're going to count that as four sons, and we're going to divide the estate into four, and the bechor gets two. So that would mean that the bechor gets half, and each of the other sons get a quarter, instead of each of them getting a third. That's the way that works. If a person has no no sons, but he has daughters, then that's the no slavchad, right? That is the daughters inherit. If there are sons and daughters, the sons do inherit, the daughters do not. This is all from the Torah point of view. What if a person has what if a person has either a son or a daughter, but that son or daughter passed away before they did. They predeceased their parents, God forbid. What happens? So there's an idea that a person can be morish bekever, that they inherit and they bequeath in the kever, even though they passed away. So, for example, if you have somebody, let's just make up a name out of nowhere. Let's say his name is Yaakov, and he has a son whose name is Yosef. And Yosef has a son whose name is Menashe. Let's just say. So if Yosef were to predecease his father Yaakov, Menashe would be in his place. So the grandson would get that benefit. And that means that even though there's a next, where we would have said before that, well, if there's no son, then who's next in line? Well, then it's a daughter, or then it's his father, or then, whatever. If the person who stands to inherit existed, it's not that he had no sons, he had sons, but that person died, or those people died, but they themselves have Yorshim, right? They have inheritors, they have heirs. So then those heirs would be in that place. So again, the order is the sons have precedent over the daughters, and whoever at any step in the process, whoever that is, if they existed, but then they passed away, if they themselves left heirs, then those heirs are in their place. So a man passes away and he had a son, but that son passed away, but that son has children, so then those children would be the inheritors. Let's say a man does not have children. He never had children. Or he had children, but unfortunately, they all passed away and they didn't have children. So then who's next in line? So then it's his father. What if his father passed away, right? Maybe that's the more common scenario. So then the answer is, well, we just said, if a person passes away and they existed, so they inherit, but they passed away, so then even in the grave, they bequeath. So what does that mean? It means that the father's sons or daughters, right, are the ones who are going to inherit. What if, so that would be the brothers of the person who we're talking about, right? The brothers of the person who passed away. So in our scenario here, right, where we're talking about Yaakov, right, a person named Yaakov. So let's just say that Yaakov had a father whose name was Yitzchak, but when Yaakov died, his father Yitzchak had already passed away. So then, well, so who inherits Yitzchak? His sons. Okay, well, who are the sons? Well, one of them is Yaakov. He passed away. We already dealt with him. But he has another son. Who's that son? His name is Esau. So that son would stand to inherit. Now, again, maybe that son passed away, but if he himself had children, so then those children would inherit. What if they didn't? What if there's nobody? So then, if the father, right, so if the father doesn't have any children, so then who inherits? His father. So it'll keep on going back. Every generation will keep on going back like that. And then whoever that person is, and whoever is in line with them. So it'll start to be, uncles and then cousins and then, great uncles and then the second cousins and all these things. But eventually there is somebody out there. Anybody who is a descendant of Yaakov Avinu has some type of Yoresh, some type of halachic heir. What if the person is not a descendant of Yaakov Avinu? What if the person is a Ger Tzedek? What if the person is a righteous convert to Judaism? So if they themselves have children, then those children inherit like anybody else. But a convert is not related to their family of origin. They come out of the mikveh, they are a whole new person. And so therefore, if they themselves don't have children, or what's maybe common is that you have a family that converts. So you have, husband and wife and children, and they all convert together. The husband and wife get married under the chuppah, so they're related to each other. But from the halachic point of view, those children are not the halachic children of their parents. So they don't actually follow the Seder HaYerusha, right, the order of inheritance. But whatever that would be, it's not going to revert back to the father either, because this convert who we're talking about his or her father is not related to them because they weren't born Jewish. So from a halachic point of view, the estate of a ger tzedek is hefker. Anybody can take it. Okay, we're going to deal with all of these things here. Also important to know that when we speak in terms of of brothers or whatnot, it does follow the father's line, not the mother's line, and I think that's our details for now. The important thing to know is the halachic order of inheritance happens passively. It happens just because it happens. So so for example, from a halachic point of view, I was dealing with a family where there was one daughter, single daughter, right? The only daughter, she's the only child. So I was like, so she inherits her father, right? That's the slavcha, that's the single daughter. So so her father was coming to she was going to use our cemetery for the burial for her father, and I went to the apartment, just to meet with her beforehand, explain a few things, and there was some issue that came up with the apartment. I forget what it was, but the point is that from a halachic point of view, that's her apartment, right? He owned it when he was alive. It doesn't matter what documentation he did or didn't do. From the halachic point of view, she is the owner. She just becomes the owner because that's how the halacha works, that person's assets belong to their halachic heirs automatically without anything happening. Now, that becomes very important because that's for two reasons. Number one is that that's not necessarily the way that a person would want their assets to be distributed, and we're going to talk about that in a moment. And the other issue is that if you do nothing from a civil law point of view, from Georgia court point of view, Georgia court is not necessarily going to distribute one's assets according to halacha. So the problem becomes if there would be a conflict between the way that the court distributes a person's assets and the way that halacha says the assets are distributed, you have a situation of people who are using other people's money because the halachic heirs own that immediately at the death of whoever it is that they're inheriting. So the idea that we would leave it to nothing and just let it happen, that creates a situation where what you have is you have confusion, you have chaos potentially, but you don't have shalom. The idea behind this month, Legacy Month, the idea behind this fund called a Legacy Fund, it's so called for a reason that we are deciding what our legacy is going to be, and what we want the legacy to be might be different for each of us, but I think everybody definitely wants a legacy of peace. We do not want to be the cause of strife after we die. We don't want to be the cause of strife while we're alive, but we don't want to be the cause of strife after we pass away. And so therefore, it is supremely important that these things are made clear and that this way everybody knows what to follow. So we can't just leave it to chance. And what that also means is that it's not just that it's made clear. It needs to be made clear in a way that is going to hold up in civil court, and it needs to be made clear in a way that is going to hold up in halacha and in Beis Din. And so therefore, as we go through this, there are going to be certain things we're going to say, well, maybe it works according to this, according to this shita, according to that, b'diavad, all these things. We want none of that. We want to make sure that there's, because all of that leaves room for fighting afterwards. And we don't want any room for fighting afterwards. We want this to be clear as day, crystal clear what we want, and we want it to work, and that there's nothing to even argue about. So that's what we're going to go through. Now, let's say you have a situation, getting back to the idea that a person might not necessarily want their assets distributed according to the default halachic distribution. So there's first and foremost, there's a very important distinction to make. It's a fine point, but it's an important point, just like this, that it's important that this be coming from, let's say you have a man who has, he has two sons and a daughter. Okay. So the issue is that he just wants his daughter to benefit from his estate. That's what he wants to do. He wants to help out his daughter. So that's fine. That's fine. But if the idea is that that a person feels that the Torah is unfair, or the Torah system is unfair, something like that, that's wrong from a hashkafic point of view, that we're not trying to circumvent the Torah. And in fact, one of the issues is that we're not allowed to circumvent the Torah. You're not allowed to disinherit a halachic heir, partially or fully. So what does that mean? It means that if a person would simply do let's say our friend over here that we're talking about who has 2 sons and a daughter, if he would simply do a Georgia will, last will and testament, and say, distribute everything, equally in thirds, okay? So the problem with that is whether or not it works from a halachic point of view, we can argue about, but it's definitely wrong from a halachic point of view, because what he just did is that he just partially disinherited a halachic heir, because a halachic heir was due to get something, and he just gave that halachic heir less. So how do we avoid this? So there are a few things. One idea is that a person can give a gift during their lifetime. A person allowed to give gifts during their lifetime. A person who is close to death is allowed to give gifts during their lifetime. Even on their deathbed, they're allowed to give a gift. The issue with all of it, though, is one issue with it. So in other words, a person could just very simply say, they could write a will and they could say that they want it to take effect right before they die. Problem with that is a couple of problems. One problem with it is the way the tax law works, that would be a gift that somebody's receiving, in this case from their parents while they're alive, and therefore it would be taxable in a much different way than an inheritance. That's issue number one. Issue number two is that if it's a gift, it's going to take effect right now. So even though a person's saying, I'm not going to give the gift until, until I pass away, but it doesn't have any effect on the assets that they have yet to acquire. And it does have effect on the assets they have now. So like really, if that were the case, a person who owns a vehicle, let's say, and now they want to sell their vehicle, but they just put in, they just wrote it in such a way that they're giving it to their kids a moment before they die. So now they need the kids' permission to sell anything. It's very, very, very complicated, right? So that just doesn't work, practically speaking. It just doesn't work very well. Not in terms of a estate planning. So very, very simply, what and we can go through, there are different ideas that people have and why they work and why they don't work and whatnot. The one thing that works very well is slightly complicated, but basically the idea is this is based in halacha, and it's one of these things where it's like there's nothing new under the sun. This is brought down in the Shulchan Aruch 2 different ways. The Mechaber brings this down as the asmachta of the Chachmei Sfarad, which is basically that it's the halachic tool of the Chachmei Sfarad, the wise men in Spain, and the Ramah brings this down as what's called a shtar chatzi zachar. So a shtar chatzi zachar is that it was very common practice in Ashkenazi Jewry in Europe that they would include the daughters in the inheritance as a half a portion of a son. So they didn't inherit the same as the sons did, but they did inherit. And this way they were able to benefit their daughters as well. And again, this goes back hundreds and hundreds and hundreds of years. The idea behind both of them is the same. The idea is that we want to create a mechanism that's going to get the halachic heirs to agree to the will. So in other words, I'm going to write what I want. Here's what I want to happen. Okay, here's how I'd like it to happen. Now, even when I'm writing what I want to happen, it's important to leave some significant portion. You can talk to your rabbi about how much that is, but some significant portion that you leave it alone, you don't touch, and you say you want that amount of money to follow the halachic inheritance 100%. The rest of it is divided the way that I want it to be divided, which is et cetera, whatever it might be. Okay, now, if that's not according to the halachic guidelines, so then how do we get the halachic heir to agree to that? And the answer is that we make him an offer he can't refuse. So the offer he can't refuse is like this. Let's go back to our friend over here who has 2 daughters and a son. Let's say he has an estate, which when he's making the will, he assumes his estate will be worth approximately $1 million. Approximately $1 million. Okay, so everybody stands to inherit approximately 1/3 of that, $333,000, right? Good. So let's assume there's no bechor, right? The daughter was born first. Okay, so that's the way that we're going to do it. So so he'll write a will that says everybody gets a third, according to Georgia law, with your professional attorney, etc. Now, so that's going to stand up in Georgia law, and then the halachic will addendum is going to say like this: from right now, immediately, I'm accepting upon myself a debt, a chov, to my daughter, who's not the halachic heir, of $1 million. I owe her $1 million, payable moment before I die. Now, again, that's not a gift. Not a gift. It's a debt. It's not a specific asset, and it's a number which is a ridiculously high number. That is the entire estate. So, but there's a condition. There's a condition. The condition is that if everybody agrees, that if the halachic heirs agree to follow the last will and testament, this other document over here, the last will and testament, so then the debt is canceled. That's canceled. What would you do? You have two choices, okay? The halachic heir can say, I'm the halachic heir, I'm going to inherit the estate of my father, and that's the way it's going to be. So we say to him, hey, no problem. That estate comes with $1 million debt. So you're going to inherit $1 million in order to pay a debt of $1 million, and now you're going to get left with nothing. Option number two is that you can say, option number two is you can go along with it and you can get a third of the estate, right? So obviously anybody in the right mind is going to do that. Now, maybe some of you might think to yourselves, hey, wait a minute, maybe there's a way to do this where there could be like a little bit of a koinonia between the daughter and one of the sons, that son could refuse, and therefore you have it, and then she gets the million, and then she splits with him 50-50. So there is a line in there in order to avoid that. If you didn't catch that, don't worry about it. But there's a line in the halachic will addendum that avoids that. What this does, just again to review, what this does is that it allows the system of halachic inheritance to happen. It allows it to happen in a way, almost you could say unencumbered. That I'm not messing around with the halachic system at all. I'm certainly not disinheriting a halachic heir. It's also important when you write the will. And again, it's a very sad situation when this happens. If a person really does have somebody who is their halachic heir, who they are trying to avoid completely disinheriting the will, you really need to speak to your rabbi. You really can't do that. There needs to be something that goes to that halachic heir. Sometimes that's a very close relative, sometimes not a close relative. So again, back to the system. So what this system does is that it makes it that the halachic system is in place, it's happening, unencumbered. The Georgia state law is followed 100% because I went to a competent attorney and I had a professionally done last will and testament by a professional attorney. Me, Rabbi Yaakov Lyons, I am a little bit skeptical about all of these things. And I was speaking to a New York State judge about it, and I asked him his opinion, and he basically convinced me that you really should go to an attorney and don't do one of these, online things or do it yourself, because there have been plenty of times where cases in front of him where there was language in a will, and it did not mean what the people thought it meant. And they thought that they were doing one thing, but all the judge has is what's in front of him, and that word legally does not mean what you think it means, and definitions get mixed up, and then things really happen again. We need clarity, because clarity is peace. So it's important to spend the money and to go to a lawyer and get it done like that. Also, to speak to your Rav, you can go to NASCK.org also to find these halachic will addendums. There are a few different ones out there. There's a Rabbi Marburger who has one, which is wonderful, and he has a whole contrast explaining this, which is really the basis of my presentation here today. I meant to recognize that at the beginning. I apologize. But Rabbi Ari Marburger has a terrific piece on it with a halachic will addendum. And there are others out there. I'm going blank about who else has them. I'm sure the Beis Din of America has it, and et cetera. You can find them out there. They're all basically the same idea. The halacha is followed, because what we did is that we used the wisdom of our ancestors brought down more than once in the Shulchan Aruch of the Asmachta of the Chachmei Sfarad or the Shtar Chatzi Zohar, that basically creates a situation where it induces the halachic heirs to follow the wishes of the testator. And that is exactly what we want to do. They're going to choose that. And very simply, that's how it is. A married woman the halachic addendum is slightly different, where both the husband and wife need to sign it. If a married woman wishes that her husband inherit everything, she really does not need. That would be your one situation where you don't need to do anything, assuming that that is the case. And as far as a ger tzedek, you should speak to your rav about how to do this. It is going to be slightly different because there are no halachic heirs who need to be induced into this. With all of this, just in conclusion, I want to again and again and again congratulate all of you for being here tonight, for taking responsibility to do this. Major kudos to Beth Jacob for again, just having a legacy fund, having a legacy month, talking about these issues, bringing them to the forefront. Wonderful, really mizaka the rabbin by doing this and helping out so many people. I hope it's a very big help to the shul as well. Certainly greatly deserving of it, and greatly deserving of the support of the members who benefit from so many programs from the shul. I'm Rabbi Jay Lyons from NASCK, National Association of Chevra Kadisha. We deal with all things end of life and really promote the idea of taking responsibility and doing these things and being proactive about it. It's a little bit of a stigma around these things, but really, as uncomfortable as it might be to contemplate our own mortality, or as uncomfortable as it might be to confront the issues of who's going to inherit what, it is far more uncomfortable to contemplate the idea that there would be any type of confusion or fighting around us, around our medical condition, or around our estate planning. I do want to say one more thing, which I just remembered just now, that I realized just now that I neglected to mention, which is that the Advanced Medical Directives is not an end-of-life issue. I mean, it is, but it's not necessarily an end-of-life issue. Anybody who could be in any situation where they would need medical help and they could not speak, and that means, God forbid, a car accident. That means even, whatever, fainting from sunstroke or something like that. If a person is incapable of speaking or capable of communicating, they really need to have Advanced Medical Directives. They need to have that halachic agent, the healthcare agent. They need to have the halachic authority. Anybody over 18 really should do this. Anybody over 18. You have kids who are maybe away at yeshiva or college or seminary, or if they're in Eretz Yisrael, I believe there is a different way to do it through Kupat Cholim, but there is a similar form. And if they're anywhere, in the States, then they definitely should do this on their own. But it should not be assumed that the parents just take over the authority. Again, in conclusion, congratulations to all of you for doing this. Please do the Advanced Medical Directives and have it signed in front of a witness and send it out to everybody. And please be in touch with us if you have any questions. Thank you all.